Good evening. My name is Carl Tanksley. I'm the Director of Legal and Labor Relations, and I want to welcome you here to our Governance 4 presentation this evening. Governance 4 is part of the mandatory training program, and glad that you were able to show up tonight and participate. It's going to be an interesting presentation. We're going to cover some cases and some updates for you. If you have any questions or issues, you can just go ahead and ask a question. We'd be more than glad to take the time to answer it. But because it is a longer type of presentation, I'm going to go ahead and jump right into it. So, to start with, the first case I'm going to talk about tonight is Barilla versus Cliffside Park Board of Education. This is a case that has raised a bit of controversy in the state recently because our appellate division decided that when the board negotiates a contract with a union, that the board really has to be attuned to what those provisions are, even if the union should agree to the terms that are being negotiated. Now, in Barilla, we have a situation where the predecessor contract had a clause in it that provided for a payout of accrued and unused sick leave for certain individuals, certain employees who had enough years in the district. When they retired, they received a $25,000 payout, up to $25,000, for their accrued and unused sick leave. In the successor contract, both the board and the union negotiated that provision down from $25,000 down to $15,000. And even though it only affected a handful of individuals in the district, 4 or 5 or so, those individuals were not happy because obviously if you're retiring expecting $25,000 and then only receive $15,000, you're going to be a little bit upset about that. And that's what happened here. So these individuals who were affected by the change in that clause decided to file a petition, and it came before the appellate division. And the appellate division said essentially that the board, and the appellate division blamed the board completely, the board could not negotiate the way it did to take away those benefits, those accrued and unused sick leave benefits. The appellate division said that once a benefit is vested in a person, once it vests because of the sufficient time they've put into the district, that can't be negotiated away. The board can't divest them of that benefit. So as I said, this matter is going before the Supreme Court. The Supreme Court has granted certification, and later on this year, hopefully late spring sometime, we'll hear an answer from the court because school boards did participate as amicus in this matter. One of our arguments was one that we hope the court will take up, and it's the fact that it's called collective negotiations, right? The union as an entity bargains on behalf of all of their members. And if the union agreed to those provisions, to those clauses, then everyone in the union has to abide by that. They voted up or down, and the majority of the members voted it up. So if the court, or what the appellate division has done, is basically allowed individual members to negotiate on their own behalf without the union. And if this goes forward, what's to stop other individuals from doing the same thing in other districts? So instead of having collective negotiations, you have to negotiate with the union and negotiate with any individual who doesn't agree with what the union has done on their behalf.
Was this contract already ratified when they filed?
It was. It was ratified. The people who were affected voted against the contract, but the majority of members voted for it. So the contract went through, and that's when the petition was filed. So hopefully the Supreme Court will rule in the school board's favor, but stay tuned. We will have to see. Second case is Under the Sun versus Evesham, involving a daycare, a preschool, where the board was actually operating the preschool, and the board had a little practice or policy of allowing students who were underage or non-residents to participate in the preschool program. Because that violated the regulations, the school district was ordered to shut that daycare down and cease operations. So, not that happens in a lot of districts, but on occasion, we do see violations of regulations happen from time to time. Next case works out a little bit better for school boards, and it involves LM, or it is LM versus Alamucci Board of Education. And a colleague and I have this conversation all the time about homework. My colleague at school boards doesn't believe in summer assignments. He feels as though that when the kids are on summer break or Christmas break, that they shouldn't have to read a book or do any homework because it's summer break. I take the opposite approach. I think that students should do a little bit of something at least over the summer hours. But in LM versus Alamucci, we have a mother who felt the same way as my colleague did. They said it's summertime, students shouldn't have to read books or do math or do anything because that's their time. And when she received notice that there was going to be a summer assignment for her two students, one fourth grade and one rising fourth grade, one rising seventh grade, she emailed a teacher and said, look, my kids are not going to be participating in the summer reading program because I object to it. I'm not consenting to that type of program. So the summer went on, the students were assigned work to do, and the students didn't do the work. And the seventh grader in particular came back to school, told the teacher that didn't do the assignment. His mom said didn't have to. Plus, he was on vacation. So teacher said, okay, fine, thank you, marked zeros. And at the end of the marking period, although the student didn't fail, his grade was reduced because of two missed assignments. So a parent was upset. Parent filed an objection and filed an appeal before the board, first to the superintendent, then to the Board of Education. The board said, look, it's a summer reading policy. It's been that way forever. We're not going to reverse our policy just because you feel as though the students shouldn't have to work over the summertime. Parents said, yes, but actually it's not your policy. There's nothing in policy that allows the teacher to assign homework over summer break or over a holiday break. So because it's not supported by policy, it's an illegal practice, and I'd like to have those grades removed, those zeros removed from my son's report card, my student's report card and grades. Board said thank you, but no, we're leaving things the same. So the parent then appealed to the commissioner, arguing that the board's practice of assigning homework during summer and extended hours, vacation hours, violated her First Amendment right to privacy because it was interfering with her ability to raise her children the way she thought was fit. Because the students had to spend time doing reading for school, which they weren't in, and honing up their skills for a period, and it deprived them or interfered with their ability to go on vacation and have other family events. And again, there's no policy supporting this. So the commissioner said, I understand there's no policy supporting this, but it's good pedagogical practice. We've seen studies for years and years of how students lose skills over the summertime, and they need to have some type of reinforcement to mitigate the loss of those skills. And as to the absence of policy, well, as a parent, you have to prove that the board's action is arbitrary, capricious, or unreasonable. And here, it's perfectly reasonable to assign summer homework because of all the studies that have shown it. So even absent a policy, the commissioner said boards can sustain the practice of summer homework because it's good pedagogical practice and it helps maintain those skills. But for you as a board member, what I would say is just to remove this irritation, just to give parents, avoid that type of argument, you might want to take a look at your homework policy and make sure that it allows teachers the discretion to assign homework over Christmas break or over summer break. That way you can take away that argument that the parent had. Next case, Rosenblit versus Lyles is also an interesting case because in this matter, the school district had a policy, or I guess a practice, of negotiating with the union, and as part of that practice, there was a clause that actually provided for the union president and vice president to be paid their full salaries, even though they weren't providing any services to the district as teachers. The union president and vice president spent all of their time handling union matters, handling complaints or issues pursuant to the contract, and provided no services at all to the district. These taxpayers argued that that was a gift of public funds, that essentially the board was paying the union money that, and it wasn't receiving anything in return for those monies. And that's actually a constitutional violation. So in Rosenblit versus Lyles, the court actually overturned the contract and said that that was illegal to pay union officials public funds to perform union duties, essentially private duties, and not receive anything in return. Now, one of the arguments in Rosenblit was, well, teachers are paid all the time when they don't provide services. You have sick leave, and they're not providing services to the district during their sick leave. They have sabbaticals, they're not providing services then. But the court addressed those and said with sick leave, obviously there's a statute that allows for teachers to be paid when they're not working and when they're sick. And we don't want to throw teachers out of the job just because they get sick. That's, you lose all that time and experience, and that's not a wise public policy. But with sabbaticals, the court said that the district does get something in return. The teacher goes away, they're allowed to spend an extended time getting themselves refreshed, and they're able to return back to the classroom with new inspiration and most often new knowledge, because they do learn things when they're on sabbatical. So there's a benefit there. That doesn't happen when you have a teacher assigned union duties all the time, full time. Now the court left open the question of what happens when those teachers aren't assigned union duties full time, they're only assigned union duties part time. So we'll have to wait for hopefully the Supreme Court to address that, or maybe in a later decision. But for right now, full time, we know you can't do it. Part time is unclear. Now, next case, Middlesex Education Association versus the Middlesex County Board of Education. Here there was a question about the assignment of teacher duties. And it came down to a very small provision about the language of the contract, in which teachers were allowed to be assigned a certain number of teaching periods, duty periods. But the contract didn't say anything about a duty post. So the question is, what's a teaching period, assigned teaching period, and assigned to a teaching post? And for years and years in the district, teaching period involved actually handling students, being responsible for them and providing an education or instruction to those students. A teaching post was simply being on post and doing hall duty, maybe cafeteria duty, and everyone understood that practice. So because the contract didn't assign the number of posts, or didn't speak to the number of posts that could be assigned, the board actually won out in this litigation. And it was allowed to assign as many posts as they felt was appropriate, or had to negotiate something different with the union. And I'm sure the next round of negotiations will include that conversation on duty posts versus duty periods. Richter versus Oakland Board of Education is actually not a happy case, because here we have a teacher who was suffering from a condition. She was a diabetic. And because of her diabetes, obviously you need to maintain your blood sugar and you need to eat at certain times. This teacher was assigned a late lunch period, was actually in class and teaching up through 6th period, so she couldn't eat until 7th period during the course of the school day. During the first marking period, she complained to the building principal and said, I really need to eat earlier than that. Can you make arrangements or an accommodation that allows me to eat earlier during the school day? So for the second marking period, the building principal assigned her to an earlier lunch period, and that was working out fine. But for the third marking period, either the building principal forgot or didn't care, probably forgot, and assigned her back to the late lunch period. And the teacher, instead of going to the building principal and saying, last marking period we had me earlier and we talked about, my need to eat during the school day, can you reassign me back to the early lunch period? She didn't say a word. She just shouldered on and took the assignment. Unfortunately, one day late in the year, I believe it was May, the teacher, her blood sugar dropped and she passed out in the classroom. and she suffered some substantial injuries. The decision doesn't actually say, but she must have fallen and hit her face on a desk because she required extensive oral surgery, lost her sense of taste and her sense of smell, and had a number of other injuries because of the fall. And ultimately, she argued that she was suffering a shortened lifespan because of her injuries. So because of that, she filed a claim against the school district, failure to accommodate her disability, her diabetic condition. And the school district moved to dismiss that case because according to the law, if you're trying to prove that the board discriminated against you because of your disability, you have to show that the board acted intentionally. And there was an adverse employment action. Here, there was no adverse employment action. She didn't lose any money. She wasn't assigned to a lesser desirable position. All that happened is she was denied the lunch period that would have best suited her. Number one. And number two, the district argued that this teacher also had an obligation, or at least the ability, to mitigate her own loss by either taking a snack with her, an orange or an apple or something, or coming back to the building principal and saying, look, we had an understanding. At least I thought we had an understanding. Can you move me back to the earlier lunch? She did neither. So the board moved for dismissal. The court in this case said, no, we're not going to dismiss the case at this time. Because there are occasions where even without the board showing, or without the teacher showing, that the board acted and imposed an adverse employment consequence on her, it's possible that she suffered a damage, suffered a disability, suffered some injuries due to the board's failure to accommodate her condition. And it looks like this might be the rare case where there is no adverse employment action, but there is a failure to accommodate. So the court allowed the case to move forward. But what's also important about this case is there's a claim of punitive damages here, in that if she can claim that the building principal was either willfully or negligent and disregarded her condition, then punitive damages could be awarded. And if a jury was to award punitive damages, we don't know what the jury might do. The jury might say $10,000, might say $100,000. So you want to try to avoid that kind of situation. So administration should be aware that if there is an accommodation request, they should pay attention to that and do everything they can to accommodate that request. But at the same time, the employee has an obligation to come forward too and make sure that the request is understood. And if it's not being accommodated, make sure that they make that known so an accommodation can be made. There is an obligation on both parties to comply. Now, Manful versus Trenton Board of Education was an interesting case because here the board had appointed individuals to a stipend position, the boys basketball coach. In this case, they appointed a substitute teacher to that position. Apparently, when the board appointed this substitute, his teaching credential, his sub-certificate, had expired. And we know that you can't have a person in a position who's serving under an expired certificate. So the board had to let that person go. Next in line was Mr. Manful, who was a certified teacher and had applied for the basketball coaching position, but the board didn't award him that position. The board left the position vacant. Once the substitute got his substitute credential renewed and reinstated, the board then appointed him to that position. And Mr. Manful said, hey, wait, you can't do that. He wasn't qualified. Plus, I'm a certified teacher. You can't put a person in place who is not certified. So the issue was that the substitute certificate had expired. At the time that the sub-certificate had expired, regulations required that in order for a board to appoint a substitute to a stipend position, the board had to demonstrate that there was no eligible or qualified individuals. And Mr. Manful's argument was he was certified, he was qualified, he should have been appointed to that position, especially because the substitute was not certified. and the board shouldn't have left the position vacant. They should have filled it with Mr. Manful. But in this case, between the time that the substitute was withdrawn from his position, the regulations changed. And the new regulation stated that there was no obligation on the board's part to demonstrate that there were no other qualified individuals before they could appoint a substitute. So once the sub got his new substitute credentials, the board was allowed, pursuant to regulation, to appoint him, and that's what they did. So Mr. Manful unfortunately lost out on his case because of the change in regulations. Now, next case, moving forward, Nash versus the Board of Examiners. Here we have an alternate route teacher who was going for his teaching certificate, but was unable to complete that at the time. And when he did complete his requirements to finish up the certification, the Board of Examiners said, the certification requirements have now changed and you don't meet the new standards. Makes sense, right? If you start the process, the regulations change before you complete the process, you have to complete the new standards, the new requirements in addition. But Mr. Nash had a good argument. He said that, yes, I understand that I should have completed it in a timely fashion, but I couldn't because I was in jail. I spent 22 years in jail, but I was wrongfully convicted. And actually, I can prove I was wrongfully convicted because not only was I released from jail, my criminal record was expunged. And had the state not wrongfully convicted me, I would have completed my teaching certification in a timely fashion 22 years ago. So because the state made a mistake back then, I'm being punished twice now by being denied my teaching certification. The examiner said, Mr. Nash, that's unfortunate that the state did that to you, but we can't help you. We have to ensure that the students that are being taught by appropriately certified individuals, and that means you have to have up-to-date credentials and meet the new standards. So the interests of the students outweigh the needs of the teacher, and even though he was treated unfairly by the state for 22 years at least, Board of Examiners didn't buy his argument and didn't give him his teaching certification. Now, what we've also seen recently, the next couple of cases are going to demonstrate this, hopefully fairly quickly, is that boards are looking for ways to save money in almost every way they can because of some of the cuts that they've been suffering. And in DeGraff versus Belleville, that's what we see, that a board decided that they had to RIF a dance teacher because they just were running out of money. The dance teacher said that you can't RIF me, I'm the only dance teacher in the district. And without me providing dance instruction, you don't have a dance program anymore. And NCLB standards require that you provide dance instruction, and the state standards require dance instruction. Well, what the commissioner determined was that the standards require a dance program in middle school and high school. A dance program and dance instruction, they're two different things. So the commissioner said because they are two different things, that the district can go ahead and do what they need to do with regard to that position as long as the students get, as long as the district fulfills its requirements for dance toward those students. And as to NCLB, the commissioner said, well, that's not under my jurisdiction. I don't do federal law. That's got to be filed in a court. So Ms. DeGraff lost her argument. Same type of thing happened in High Point when a student assistance coordinator was also RIFed by the district, but he had what he thought was a stronger argument. It said the statute requires, not just a regulation, not just NCLB, but the state statute requires an SAC coordinator, student assistance coordinator in every district. It's written right there in the language. Here, the court said, the commissioner said, yes, that's correct. The statute does require a student assistance coordinator in every district, but it doesn't require an actual coordinator position. It requires the coordinator services be provided. It doesn't say who's going to provide those services. And as long as the services are provided by someone who is certified, it doesn't have to be an employee. What the statute does say, Ms. Romeo argued, the statute does say that the person has to be appointed. And the statute actually does say that. But that's only for the first 5 years of the Student Assistance Coordinator program. And that was during the voluntary pilot program. After the first 5 years of the program, because it was discretionary as to appointing the individual, the board didn't have to keep that person employed as long as they made sure that the services were provided. So that's what happened with Romeo and High Point. Now, Agreement versus Board of Examiners. We have a teacher here who had been, I believe, a welder in his professional life, working for his company, applied for a teaching certification, and one of the requirements is you have to demonstrate 8,000 hours over the past 10 years of actual employment in the field, which sounds like a lot, but really it's only 15 hours a week. So Mr. Greenman said, I'm doing more than 8,000 hours. You can see that here. But one of the problems was during the last 4 years of his employment, he was employed as a welding instructor. And the regulations discount any time provided or any time that you serve as a teacher or an instructor. And because Mr. Greenman was teaching his coworkers, his younger workers, in a teaching position inside his company, he wasn't given any credit for that, for those years serving as a teacher. So even though he had more than enough hours, many of those hours were spent training people how to weld, which you would think would be exactly what you would want in the classroom, with someone who knows not just how to do it, but how to teach it as well. But here, the commissioner said, no, you don't meet the standards. So Mr. Greenman lost his case. So the next case I'm going to talk about is Gomez versus Elizabeth Board of Education, which has a long and tortured history, which I'm not going to go into. But suffice it to say that Ms. Gomez was not a model employee. Over the past 10 years of her employment, she was absent roughly 970 days. So 97 days a year, she was out. But she said she had chronic back issues, and that prevented her from being at work every day, which is understandable in some cases, but you got to go to work, right? So the last year or so that she was employed by the district, she was in a non-pay status, meaning that they had her on the rolls, but of course not paying her salary because she's not performing any services. Toward the end of that period, the board said, well, we're not paying her. Do we have to continue to pay her health benefits, her health care premiums? And the board stopped because she wasn't providing services. Ms. Gomez argued that she was still employed. She was a tenured secretary, still employed by the district, and as long as she was employed, then she should be entitled to receive the benefits of her employment, which included health care payments. And the administrative law judge who heard the case initially agreed with Mrs. Gomez and required the district to pay her COBRA payments for 7 or 8 months or so. The board, rightfully so, appealed this case the case went before the commissioner. It wasn't an actual appeal. The case went before the commissioner, who looked at the case with Ms. Gomez and the health care benefits and said, health care benefits are paid pursuant to a collective negotiations agreement. They have nothing to do with tenure. So your tenure rights are to continued employment. And even though the board probably should have filed tenure charges against you, they weren't required to do so. Nor were they required to continue to pay your health care benefits. The board stopped paying your salary because you weren't working. They can also stop paying your health care benefits. So that just made sense and was a victory for the board in this case. They're rare, but we'll take them when we can find them. Corcoran versus Queen City Charter. Doesn't happen too often, but there is a state statute that says that you cannot make a teacher teach on a state holiday. And in this particular case, Queen City Charter had an in-service day on a state holiday. Mr. Greenman said he wasn't coming in because it was a state holiday, and the charter school docked his pay 1 day for that failure. Mr. Corcoran objected, filed an action before the commissioner. The commissioner said, Mr. Corcoran's right, you can't force a teacher to work on a state holiday, so they had to restore reinstate that one day that the district docked him. Merida versus Union County. In this case, a bedside instructor of 7 years, I believe, argued that she was entitled to tenure and had gained tenure in that position because she'd been a bedside instructor for more than 3 years and a day, and therefore was qualified, eligible for tenure. When the district riffed that position, she claimed that they couldn't, when the district dismissed her, they claimed that they couldn't do that because she was tenured. Commissioner decided that she was acting in place of the regular teacher. And we know that anyone who's in an acting position doesn't gain tenure because that time doesn't accrue towards tenure, because you expect the person to return to their position. In this case, Ms. Murda argued that she wasn't acting because the teacher wasn't there. There was no teacher to actually go out to the house and provide instruction. But the commissioner said, yes, that's true, but here the teacher wouldn't have been allowed to go out, and the student wasn't available at the time, so the teacher had to go to the house. So the teacher wasn't absent, wasn't that the teacher was not providing services, it's that the student wasn't there. So since the teacher wasn't acting in place of, because there was no vacancy, tenure time, the time toward tenure did not accrue. So again, teacher didn't gain tenure, and there's a victory for the board. Wicks versus Farmingdale is a matter where a teacher had exemplary, fantastic evaluations from the superintendent, but the board still withheld an increment. Why would the board do that? Well, 2 years prior to the withholding, after the evaluations were done and handed in, and the board had approved employment for the following year, this particular teacher, Ms. Wicks, had an incident involving grades with the students, and her grading of the students came under fire. She was criticized for the way she was handling or not handling that grading situation. But it was after the evaluations were done, and the board did not take action against her. The following year, again after evaluations were done, Ms. Wicks got into a confrontation with a parent, a verbal altercation that required some interventions. And of course, the board wasn't happy about this altercation with the parent. But the superintendent had already put the evaluations in, and the superintendent felt that even though she had the altercation, it was after the evaluation period, so he was going to go ahead and recommend her for a raise for the upcoming year. The board said, wait, this is 2 years in a row. We can understand 1 year where you have a situation, but 2 years in a row, no, superintendent, sorry, we're going to disagree, and we're going to vote to withhold her increment. And that's what the board did, was withhold Ms. Wicks' increment. So Ms. Wicks and her union appealed, arguing that the board couldn't, number one, override the superintendent's recommendation of the advancement on the salary guide, and number two, that the board couldn't take into consideration something that happened 2 years ago. Well, the commissioner said actually the board could take something into consideration from 2 years ago if it reflected on her overall teaching capacity. And here, bad judgment with the grading scenario and bad judgment with the verbal altercation with the parent did reflect on her capacity as a teacher. Therefore, the board wasn't being arbitrary, capricious, or unreasonable when it looked at the past 2 years of her conduct, and the board was allowed to withhold that increment. Now, the next case also involves a withholding. And this case is a little more problematic because in Trenton Board of Education versus the Trenton Education Association, we have a teacher who was having some difficulties earlier in the year. It wasn't getting his lesson plans done, it wasn't holding grades properly, was having some classroom management issues, so he needed a little bit of mentoring. But fortunately, the teacher took the criticisms to heart and did improve his performance. Things went well for the latter half of the year. Despite the fact that the teacher's performance improved, the board still decided to withhold his increment. And that withholding clearly was challenged before the arbitrator. Arbitrator said that here the board made a mistake. When it withheld the increment, it didn't have an ending date on that withholding. It didn't put a stop period. It said we'll withhold the increment this year, and maybe at some point in time a future board will restore that increment. But that's the way an increment withholding works, because when the board withholds that increment, the reason they do so is because they want the teacher to improve his performance. And there's an expectation that if the teacher does improve his or her performance, that at some point in time a future board can restore that withholding. But that's entirely up to a future board, which is why there is no termination date on that withholding. Despite the fact that this has been the rule in New Jersey since forever, this arbitrator said, no, that penalty of an indefinite withholding is too harsh. Well, the board argued that they couldn't restore the increment. Well, they could have restored the increment this year, but that wasn't really a punishment. That's not a withholding. That's kind of just a delayed salary. So the teacher would get the full salary during the course of that year. And they couldn't state a date in the future to restore that increment because that would infringe on the authority of a future board, which the present board can't do. That's a decision for the future board. Here, the arbitrator said, despite the fact that the board had a valid basis for the withholding, the indefinite withholding was too harsh a penalty. Therefore, the arbitrator took it upon herself to restore the increment and ordered the board to repay that lost salary at the end of the year. This matter went before the appellate division, and the appellate division upheld the arbitrator. So we have a new rule on increment withholdings in the state. That was at least surprising, if not shocking. Now, certificates of vega. Sometimes boards find themselves in a situation where they've hired a bunch of teachers, and in September, a teacher or so will find a bigger, better deal and not show up to work, move on to a different district. If that happens in your district, board members sometimes don't know or have never been informed that if that happens and the teacher does not give 60 days notice, the board can actually file an action before the Board of Examiners to withhold that teacher's or suspend that teacher's certificate for up to 6 months. And that's what happened here in certificates of vega, is the teacher did not provide the proper notice, and the board actually went after her certificates and was successful in having that her teaching certificate suspended for 6 months. So a little bit of leverage that boards have over teachers if they find themselves in that situation. Also, next case, real quick, Cummings versus Egg Harbor, Little Egg Harbor. We have a teacher who was having, again, some difficulties. Was actually seen napping during faculty meetings. And not just, a little head nod here and there. We'll have a little cat nap or have some difficulties paying attention at the end of the day. She was actually knocked out sleeping. She was so far into her nap that people were taking pictures of her. Not a good look. Also, this teacher happened to be in the office toward the end of school one day and overheard a phone call that a clerk was having with a parent. Parent said that she wasn't coming to school to pick up her child because she had a really bad hangover and was going to be late. So this teacher, overhearing the conversation between the clerk and the parent, told the clerk to call DIFAS and get DIFAS involved. Then kind of walked off and didn't tell the building principal or report to any administrator that she ordered the clerk to call DIFAS. So you know what happens when DIFAS shows up, or DCP&P I should say, Child Protection Services. They do a full-blown investigation and it turned into a huge thing. So because the teacher was sleeping during faculty meetings and made a really bad judgment call to call DCP&P, the board required her to undergo a physical examination. Because whenever a teacher evidences a deviation from normal mental or physical health, the board has the right to order a physical or mental examination. And that's what happened here. Now, I don't want you to think that it's just that easy as saying, here, go get an examination, go see our doctor, because the teacher also has rights. The teacher has the right to object. The teacher has the right to go to his or her own doctor to provide a counter opinion, which they usually do, because the district doctor, physician will show some type of deviation. The individuals, the teacher's personal physician will say, no, everything is fine. So you usually have to go to a third independent doctor to make a determination and get a third independent judgment. And of course, who pays for all of this? Well, the board has to pay for all this. So yes, you can remove people and have them either go through an examination or take further steps against them, but it's, there are a lot of hoops that you have to jump through. Tassoff versus Pleasantville. In this next case, Tassoff versus Pleasantville, deals with the sick leave bank. And some board members may be involved in the sick leave bank, may be on the committee. And if you're on that committee, you want to make sure that you follow all of the rules. Because in this case, Ms. Tassoff applied for leave from the sick leave bank and was denied. But the sick leave bank was late in notifying her that they were denying her that benefit. So when Ms. Tassoff reapplied, the committee again said no, but again was late in providing notice. So Ms. Tassoff did go ahead and take leave, provided documentation for a third time, and the third time the board said, okay, the committee said, yes, okay, we'll approve this leave. Even though the leave was 2 months ago, we'll go ahead and approve it. Now, we can't give you leave, and we can't pay you for the leave that we would have awarded you, but what we'll do is if you're sick in the future, we'll award you the right to use that sick leave in the future. Ms. Tassoff said, no, I don't know when I'm going to be sick again, or if I'm going to be that sick again, so I'd like to be reimbursed for the leave that I should have been given. The committee said, well, yeah, but we can't reimburse you. The statute doesn't allow for that. But the commissioner said, even though the statute doesn't allow for that, committee, you really should have followed the rules. You should have provided her proper notice. So we're going to allow you to, or order you to reimburse her for the sick leave that should have been awarded her when she was sick. So little lesson, if you have that practice, if you have a sick leave bank in your district, you really want to make sure that you abide by the rules of the sick leave bank. Deach versus Camden County, Camden County Educational Services Commission. In this case, Ms. Deach's school district ripped her position as a media services specialist and outsourced her position to the Ed Services Commission. Ms. Deach filed a claim against the Ed Services Commission saying that my position was with the district, my position was moved to the Ed Services Commission, I was with my district, I'm not out of a position, obviously I should be in my position that is now with the new Ed Services Commission. Commissioner said, no, it doesn't work that way. You were never employed by the Ed Services Commission, so you don't have a claim against them. If you have a claim for the RIF, it's going to be against the district. You're suing the wrong people. So Ms. Deach had no claim, so apparently, unfortunately, she was out of a job. Next case, certificates of Gefrida. In this case, Ms. Gefrida was teaching a newer teacher in district and was very friendly with some of her male colleagues. In one case, giving them a hug, another case, a kiss on the cheek, another case, a little inappropriate touching was going on. When her male colleagues complained about this inappropriate contact, Ms. Gefrida apologized and said, you know what, I'm sorry, I'll voluntarily resign, and resigned from the district. Complaint was filed, but nothing really happened with it. So 8 years go by, and the complaint is revived. And during that 8-year time span, Ms. Gefrida had gone to a new district and hadn't had any issues whatsoever with anybody. But when that complaint was revived, the commissioner said, even though it was 8 years ago, and even though you've been a model employee at this new district for 8 years, and even though you voluntarily left, sexual harassment is sexual harassment and is not to be tolerated. So that 8 years of good behavior didn't warrant any lessening of the penalty for Ms. Gefrida. She did have her certificate revoked based on her sexual harassment of her colleagues.
There's no statute of limitations or anything?
You think there would be. but in this case, no. The case was actually filed timely, but administratively, one judge had the case for a number of years. It started the case and then resigned or retired. It was handed to another judge who backburned it, and I think it was handed to a third judge. So that's what happened over that 8-year time span. It just never got processed. So unfortunately,
Well, due process,
right, justice delayed is justice denied, right? But in this case, it was extremely delayed. Now, Middle University Board of Examiners, you've got to actually fulfill the requirements to obtain your certificate. That's obvious, so I'm going to move past that one. Certificates of Carol, because I am running late on time. If you're going to file, just an order of advice to individuals who are filing for a certification, teaching certification, and for board members as well, if you file false documents with your application for a certification, that fraud is going to be held against you if anyone finds out. And in this case involving Carol, she filed a letter of recommendation from one of her professors, which was false. On a reference check, the professor said, that's not me, I didn't write that letter. Obviously, the examiners found out about it and denied the certificate. So you don't want to have or revoke the certificate. You don't have someone working in your district who's going to lie about their eligibility. So that's maybe one of the questions you want to ask if before the person was hired, they were properly vetted and their credentials were checked. Next case, the tenure arbitration of Odiasi in Newark. A very simple lesson here. There was a case of inefficiency, and the administrators in Newark did not come up with a corrective action plan for the teacher. They decided to rely on the teacher's professional improvement plan. The arbitrator in this case said, no, you can't rely on the teacher's professional improvement plan because the corrective action plan is designed specifically for the inefficiencies that have been identified in the evaluation process. The professional improvement plan isn't targeted that way. Therefore, there are two different documents. You can't rely on one to do the other's job. So if in your district you're going through inefficiency charges, you want to make sure to ask administration whether the teacher has a specific corrective action plan to address those inefficiencies. And if not, then administration really should have that in place. Tenure arbitration of Porter is a wonderful case because in this case we have a teacher with 27 years of experience and not a blemish, not a mark on his record. Teacher is a basketball coach, teacher is a mentor, and is loved by the community. Teacher sees a student who's kind of shy, kind of withdrawn, and figures, well, I'm the assigned mentor, I'll go ahead and mentor this student. Gets the student involved in basketball, is actually helping to draw him out of his shell, and the student's doing well. But Mr. Porter says, I can do a little bit more with the student. Goes to the student's parent and says, I know basketball practice sometimes run late. Would you mind if I brought the student home personally instead of having him wait for the bus, or it'll just be much easier, much more convenient for you? Mother, not speaking English, agrees. So Mr. Porter starts taking the student from basketball practice to the student's home. Except on at least one occasion where Mr. Porter didn't take the student to the student's house, Mr. Porter took the student to Mr. Porter's house. And at Mr. Porter's house, Mr. Porter put what he called blessed cream on the student's back because the student was sore, maybe? Not that the student had any injuries, but Mr. Porter felt that this blessed cream would help. And then transport the student home. Now, no allegations of any misconduct, no allegations of any wrongful touching or anything like that, but when the board found out about this, they were not pleased. They were really not happy and sought to terminate Mr. Porter by filing tenure charges. Tenure charges go through. The arbitrator says, well, there's no evidence that there was any inappropriate touching. And Mr. Porter's got an unblemished 27-year career in the district. We're not going to punish him for that one mistake with a blessed cream. We're going to put him back in the classroom. But we're not going to let him mentor any more students. So this teacher was placed back in the classroom, despite the board's best efforts to protect its students, which is what board members are really supposed to be doing, right? The arbitrator overruled the board and put Mr. Porter back in the classroom. And it begs the question, with the new sexual assault statute being extended and giving people additional time to file claims against their harassers or their employers, they have to wonder whether this case might show up in 10 or 15 years where there is an allegation that there was some sexual touching going on. And if that's the case, will Mr. Porter be held liable, or will the district be drugged into the situation?
What about the arbitrator?
Yeah, what about the arbitrator? Good question. So we'll have to see. A couple of really quick cases on inappropriate language. In Hoskins, Milwaukee, is how I'll mispronounce that. We have a teacher who was allegedly using profanity in front of students. Students were offended, and one student, as you can see, had to leave the classroom. But in this case, when administration spoke to the students, they got statements from the students, but the administrators wrote down what the students said. Didn't have the students sign it, didn't date it, but wanted to admit that as evidence that the teacher had engaged in profanity and misconduct. Hoskins Milwaukee said, yeah, well, I didn't do anything wrong, plus there's no evidence against me. Now, no one wants to have a child go to court and testify, because that's one of the worst things you want to do. It's traumatic to testify against a teacher. You want to protect them against that. But at the same time, if you're going to file charges against the teacher, you have to have credible, sufficient evidence. And there's a way to get that evidence without traumatizing the student and documenting that evidence for use in an arbitration or hearing. So if that's going on in your case, you want to talk to administration to make sure that your administrators understand what those techniques are, or limit the questioning to appropriately trained individuals, because you don't want to have a case where you should be getting rid of a teacher, but you lose on an evidentiary standard. So it's just a training piece. Piscataway versus Serpico. We have a teacher who loses it in the classroom, is upset because students wouldn't settle down. Students are singing, dancing, whatever. Teacher decides to express his anger by reciting some negative rap lyrics that included the use of the N-word. Students are obviously and rightfully upset about this. Charges are filed. And the teacher in this case, Mr. Serpico, was let go because of the use of the N-word. And that seems like it should be fairly standard. I mean, there's no excuse, and the court said there's no excuse for that type of conduct. As angry as he may have been, that type of expression was not appropriate for a certified teacher. Okay, well, I think we can all agree with that. Arbitration of Bassetti. I think you know where I'm going with this. We have a teacher who also is involved in a situation with students who are less than cooperative, but he doesn't express or recite or shout any rap lyrics. He mutters to himself some words. And some of the students overheard him using the N-word as he muttered this language under his breath. And the students reported it to administration. But Mr. Bassetti, when he was confronted with this, said he didn't say anything. Matter goes before arbitration on tenure charges. The arbitrator says, not that he believes the students over Mr. Bassetti, or that he believes Mr. Bassetti over the students. What the arbitrator says is, Mr. Bassetti may have said the N-word under his breath, but he doesn't remember it. And the reason he doesn't remember it is because he was talking to himself. It was just unfortunate that some students may have overheard him talking to himself, but there was no intent there. And because there was no intent, and he was talking to himself and doesn't remember saying that word, then obviously no harm, no foul. He should be restored to the classroom, which is what the arbitrator did, put him back in the classroom. So here again, we have a board who's taking action against a teacher who at least allegedly used some inappropriate language. Maybe he did, maybe he didn't. But the arbitrator in this case seems to make up facts and create a rationale that even Mr. Bassetti didn't argue in court in his hearing. So our issue is not with whether he did or whether he didn't, it's with the arbitrator just making up facts out of whole cloth. So a little depressing for that case. WD versus Jefferson. We have students using the N-word amongst themselves. They were pranking each other. And you would think that this would be a HIB violation, but in this case, it was not. There's no evidence that the students were unavailable for learning because of the use of the N-word between themselves. Now, a little surprising here that the students weren't found to be in violation of HIB, because we have seen other cases from the commissioner where students use pejorative terms between or amongst themselves, and it was found to be a violation. Here, I think the key is because there was no substantial disruption of the educational environment, meaning that the use of the N-word did not affect the students so severely that they had to leave the classroom. Therefore, there was no disruption to the educational environment. And because of that fact, may explain why there was no violation of HIB here. But really, it sends out a confusing message to boards, because we're taught that through the Anti-Bullying Act, that boards are responsible for creating a nurturing and supportive environment for all students, regardless. And because of prior cases, you think that would be consistent, but a little bit of inconsistency here. I wish I could explain it to you, but I can't. Moving forward, DD versus Kansas City Board of Education. We have a district claiming that employees failed to respond to repeated acts of bullying in the district. And we've seen this type of case before, so it's not surprising that the court allows this matter to go forward. But what is surprising here in this case is the parents alleged that the harassment was so severe that the students suffered from emotional distress. Okay, we've also seen that claim before. But usually in emotional distress cases, there is some objective evidence. There's records of the student's changing behavior, there's records of visits to a psychologist or psychiatrist, or there's something that says there is emotional damage going on. Here, there's nothing but the allegation. Parents had emotional distress, and the court allowed that claim to move forward. So that's something to keep an eye on. Staying with anti-bullying, a statement that cookies can make you fatter than you are is not a HIB statement, which was surprising to all of us, because we've seen head lice be HIB, we've seen height be HIB, we've seen freckles be HIB. Here, being fat is not a HIB violation, but a statement saying your father never loved you after the student's father recently passed away was found to be a HIB violation. Again,
Fatter than you are doesn't mean you're currently fat. It just means the cookies can make you fatter than you are.
even so, fatter than you are is a reference to a distinguishing characteristic, right? A student's weight. And the HIB statute says you can't make any reference, you can't bully someone, single someone out because of a distinguishing characteristic, even head lice. So I would think weight would also be a distinguishing characteristic. But no, the commissioner said no, or the board said, and the commissioner agreed, not HIB, not a HIB violation. DeFalco versus Hamilton Board of Education. Speaking of HIB matters, fortunately, you don't have to have a full-blown evidentiary hearing. You don't have to have a 2-hour session with examination and cross-examination and everything that goes with a full-blown trial, because it's just a HIB hearing, and if the teacher is found to be in violation, they're not going to lose their job, at least for a first offense. Maybe there's a letter in the file. So the court has said, or commissioner has said, you don't have to go through everything with regard to providing the evidentiary standard in a court of law, because the penalty isn't that great. That being said, in Young versus Edry, you do have to provide the teacher with some evidence. You can't just say you're in violation of HIB and not provide any proof or evidence or statements that there is a violation. Because the teacher has the right to defend him or herself and has the right to see what was being said about him or her in those statements. So even though the statute says that parents are entitled to the HIB evidence and doesn't mention teachers, it's not fair to prosecute a teacher, even if it's only for a HIB violation, without allowing them to see the evidence against them, which would be the HIB statements. Cobrick versus Stevens. A little bit complicated, but we have 2 sets of students in 2 different schools. First school, Mr. Cobrick has an inappropriate sexual relationship with one of his students, and then moves on to the second school. At the second school, Mr. Kobrick also has an inappropriate sexual relationship with a young lady there, who then goes on and graduates, goes on to college. Student comes home from college, tells mom about the consensual sexual relationship. Mom files a complaint and finds out that the school district actually had some knowledge of the prior incident at the first school. At the first school, administration did interview the first girl's father and the first victim herself, both of whom said that there was no relationship, that nothing wrong happened. So because the school did their homework and spoke to the actual victims who lied and denied the relationship, the second school was not held liable under the statute, which was right as Pass the Trash was being enacted. So no liability there, which just goes to show you that administrators really have to do their homework and ask all the appropriate questions in order to protect the district. ARCOS versus CRU, the criminal history unit. A bus driver's license was suspended, driving license was suspended because she failed to drop a student off at the end of the run. And we've seen a statute that says if a bus driver fails to drop a student off, their license can be suspended. Here, yes, the bus driver missed the stop. The student was supposed to get off at a certain stop, didn't get off at that stop. Bus driver pulls off. Parent says, "Where's my kid?" Calls the school. School calls the bus driver. Bus driver turns around, says, "Yes, the student was sleeping." Dropped them off at the appropriate stop. No harm, no foul. But because that stop was missed, the school district alleged that the bus driver was in violation of the act. And the commissioner said, yes, the bus run ends where the student is supposed to be dropped off, not when the bus comes back to the garage or back to the school. So because of that, according to the commissioner, that's why there was a violation, and that's why the driver's license was suspended for 6 months. Now, Mount Olive versus Inglewood. A family wasn't homeless where they lived in a local campground, lived in a mobile home, where there was an allegation that the students were not actual residents. There was an investigation. The investigation revealed that the students had their own individual bedrooms. There was heat, there was water, there was plumbing, there was sewage in the mobile home. So even though it was a camper, the parents had decided to live there for the duration. So that qualified as the residence for these students. In Orange City versus MM, we have a situation where parents are leaving the district and ask the district to kind of stay on because it's late in the school year. They have moved out of district, but they don't want to disrupt the student's education, and ask the board to let the student stay on. The board said no. The board is allowed to say no, and in this case, did say no, and tuition was required because the students were no longer residents. So in your district, you may want to check your policy, because sometimes policies say that when students who are graduating high school or graduating 8th grade, if they're coming up toward the end of the year, they can go ahead and stay through the end of the year. But that's not every district. So you want to check your policy to see what it says about residency, especially during the later months of the school year. LD versus West Orange, also an unfortunate situation where a grandparent was adopting the grandchild. Parent was having some difficulty, but the grandparent had some issues with the paperwork. And there was a period where the student was living with the grandparent without the appropriate documentation, without the appropriate paperwork for several months, and couldn't prove residency, and couldn't prove that the parent had actually taken custody of that child. So because the grandparent couldn't prove custody, tuition was assessed. So we have to be able to prove custody, not just intent to obtain custody. And in the next case, CM versus Springfield, where a parent leased a house to a tenant and lived in a different township. Obviously, that's not residency. You have to live in the house, not just lease it to someone. You have to be there and prove that that's your domicile. CF versus Pequannock. Parents moved into the district. Their child was placed in a certain school. Parents alleged that all students of Latinx heritage were being placed in certain schools. Therefore, that was discrimination. The board said, no, not discrimination. We just have a policy that everyone living in a certain area is going to be sent to a certain school. And it just so happened that a lot of Latinos were moving into, or Latinx were moving into that area. They're all being sent to the same school because of their pattern of moving into the district. So wasn't discrimination. It was the board's policy of making sure that the population was equally distributed amongst the schools. Doe versus Board of Education. You may recall this from last year where the Board of Education in Pennsylvania adopted, no, I'm sorry, not Pennsylvania, the Board of Education adopted a policy allowing for transgender students to use the bathroom and locker room of their preference, one which aligned with their gender preference as opposed to the gender that they were born with at birth. The policy was challenged, it was upheld, allowing students to use the locker rooms or restrooms of their choice. And there were privacy concerns that were addressed in the policy, meaning there were single stall bathrooms and single stall showers in the locker room. So this matter was appealed before the Supreme Court, and the Supreme Court denied certification certiorari, so the case stands as it is, and the policy is upheld. So boards of education should look into their, I guess, intent or exercise discretion as to whether they want to have a gender-neutral policy in schools, and may want to check with the board attorney about a recent statute on gender-neutral bathrooms in public accommodation places of public accommodation. SG versus Toms River, a special education case where students wanted to be placed in their placement, but students making sufficient progress, actually making more than sufficient progress. And because that progress is being made, there was no denial of FAPE, no denial of special education, and therefore the parent due process petition was dismissed. Colonial versus GK is a matter where a parent and school district were at odds because the student didn't satisfy the goals and objectives that were in the IEP. The district argued successfully that it's not the goals and objectives in the IEP that really count. What really counts is whether that student is receiving a meaningful educational benefit. And here, where the district court relied on just progress toward the goals and objectives, without taking into account whether the student progressed at all or received a benefit, the case was, the ALJ relied too much on the goals and objectives instead of the actual progress the student was making. So something for your district to consider. SS versus Hillsborough, student records case, where a group of advocates is running around our state of New Jersey seeking student records, seeking special education settlement records, arguably because they want to make sure that students are receiving all the benefits that they're entitled to. Actually, we think they just want new clients, new customers. So, to make a long story short, the advocates here were requesting redacted special education settlement records, and the court said no, you're not entitled to those records because there are concerns of student privacy. Even if the records are redacted, even if names and schools are taken out, the parent still has a right to say, no, there's other information out there that might violate my student's confidentiality, combined with the student record, could allow someone to identify my student, therefore those records should not be released. And the appellate division agreed with the school district here. But the matter is on appeal to the Third Circuit. So we will see, hopefully this spring, what the Third Circuit says. So stay tuned for that decision. TT versus West Essex, a student who needs 120 credits has to have 120 credits. 118 credits doesn't do it, and the board is not wrong for denying graduation for a student, even a special education student, who didn't satisfy those graduation requirements. Staying with special education real quick, in CP versus Clifton, the board is allowed to set policies on independent evaluations. If someone is going for a speech eval or a psychological evaluation, the board can set a cap on that. If the standard rate is $700, the board can say standard rate is $700, that's all we're paying toward that evaluation. So long as the board policy allows for the parent to prove why the evaluation should cost more. In this particular case, the evaluation was $4,300. Not $700, $4,300, 4 or 5 times the going rate, and the parents couldn't prove why they needed such an expensive evaluation. So that was denied. So take a look at your policy, talk to your special education director. You may want to set standard rates in your district as well. JT versus Butler. Unfortunately, in this case, the student had some behavioral issues on the bus, was throwing things and broke out a couple of windows. Transportation company said, we're not going to transport the student anymore because of these behavioral issues, and left the district high and dry. But the district has a responsibility to the student and to the parents, and despite the fact that the transportation company said, no, we're not doing it, the school district had to make other arrangements for that transportation, couldn't just deny that student, regardless of the damage being done to that bus. If a student or the parents lie about the conditions for a unilateral placement or about how severe the effects of the student's conditions are, that can be a basis for the dismissal of the parent's claim. And that's what happened in FR versus Verona. The parents made the student's condition seem to be much worse than it was, and the student really didn't need the accommodations in special education that they claimed. Ethics real quick. Stewart College Achieve versus Patterson in the matter of Stewart in the College Achieve from Patterson Charter School. Board member failed to timely file his personal relative disclosure statements and was reprimanded for that failure. So you want to make sure that you get your personal relative disclosure statement filed. Also, you want to make sure that you get your training done, which is why you're all here tonight, because in Woolridge, a board member did not complete their training in a timely fashion and was reprimanded for failing to do so. So you don't want to be embarrassed for not attending training. You want to make sure you get that done. Gonzalez versus Perth Amboy was a situation where 3 board members were involved in a litigation against the superintendent. That litigation was settled, and the 3 board members voted to approve that settlement, wherein they were named as defendants in an ethics complaint. You can't do that. If you're named in a petition, you can't be voting to settle that petition. Obviously, you have an interest in that, which is in violation of the statute. Any versus Wolf. An allegation we see fairly often is that the board president withheld information from the public because they changed the agenda. Now, you should know that the board is allowed to change the agenda so long as they're not trying to withhold information from the public. So as long as you're not playing games and trying to hide things, you can change the agenda, because we all know that agendas change even at the last minute. Even during the meeting, the agenda can change. And the board should be allowed to have that discretion to change things to meet their demands. Swartz versus Gallagher, staying with ethics. If you're asking the assistant superintendent of your shared services district to come take your superintendent's job while the superintendent is still employed in that job, that's a bad thing. You have to wait till the superintendent leaves before you talk to the assistant about taking that person's position. Thank you for participating. Thank you for staying here for the whole session.